Good morning, everybody. Welcome to episode 13 of our monthly Meet the Experts Q&A sessions with Sintons Employment Team. My name is David Pritchard, and I'm the head of marketing here at Sintons. And we'd just like to once again thank you for joining. We do have a record number of people in attendance this morning, so thank you very much for giving us your time. And we're pleased that these sessions are still providing value to you. As with previous weeks, just moving the slide on so you can see our speakers this morning. The employment team are going to answer 3 questions, although it is actually 4 questions today. Our speakers are Head of Employment Keith Land and Angela Carver. So without any further ado, I'm going to pass you straight over to Keith for question 1 of 4. Keith, good morning, and over to you.
Thanks, David. I should probably say straight off that whilst we've said we've Keith Land and Angela Carver, it is episode 13, and so we are naturally having a few technical difficulties. Typical. We've done these and have sailed through them straight the way through COVID. We start getting back into the office and look what happens. But there you go. So Angela is on and off, on and off, on and off, and so you might have me for the whole thing. But we'll see. Hopefully she'll get on and we'll be able to fill in a bit. Right, the first question, test or isolate. Why have I got that? I was chatting with a client and they rang up and I'd actually just been on holiday and got back from France and managed to avoid the quarantine by driving very fast, but didn't break the law, of course. They said, "Oh, Keith, we've had a bit of a nightmare. We've had one of our team test positive for COVID-19. And then what's come out and from the fallout is that people have been, other employees have been ignoring the 2-meter rule, and they've been driving around in cars together and stuff like that. And therefore, we've got a group of people who we've had to go and tell them to go and get tests. They've got tests, they're negative. And so we've got them back into the office or the workplace. But what do we pay them for the days that they sent them home? Do we have to pay them? I turned to the client and I said, "Oh, look, there's potentially a bit of an issue with this. You've mentioned that you've got the people back in the building, and they said, well, yeah, we've had them tested, they're negative." And I said, "Well, I'm not sure that that's entirely the end of it." And the client went, "Oh, why? But they've tested negative." And I said, "Well, it's not quite as simple as that. I think we need to dig into it in a bit more detail, because in certain circumstances, even if somebody has received a test and that's ended up negative, they still may need to continue to isolate. So having the people back in the building is possibly a no-no under the government guidance." So we had to look into it, and in short, the answer is on the government guidance. It's in a bit of a strange place because it's in the test and trace area. If you want the answers, there's a decent summary of what to do there. So what do? If you've got symptoms of COVID-19, you have to self-isolate for 10 days. And what are those symptoms? Well, high temperature, a new continuous cough, a dry cough, which is you're coughing a lot more than an hour, or 3 or more coughing fits in one in 24 hours. Then the other major symptom is a loss of change to your sense of smell or sense of taste. In that instance, the person with the symptoms should go home and isolate for 10 days. Their household members should then isolate for 14 days, and that's 10 or 14 days from the time of the first symptom. The guidance goes on to say that somebody should go and get a free test. What happens then? Person goes and gets the test. They test positive. They then have to complete their 10 days self-isolation. As for household members, they would then complete their 14 days self-isolation. However, there's then a very confusing bit that then says, if you start feeling okay, you can stop self-isolating. I think that's a reference to the person that's got the positive test, not the household members. in the circumstances. So whilst that's really confusing in the government guidance, I think your basic rules are person with a positive test 10 days, people who household members 14 days. Okay, what happens then if your staff are contacted by the test and trace scheme? Well, the short answer is if you're contacted under the test and trace because they're saying you've been in contact with somebody who has come down with COVID-19, those people have to self-isolate for 14 days. Funnily enough, their immediate family who they live with doesn't need to self-isolate. However, if the person that's been contacted on the test and trace begins to show symptoms, they then have to isolate for 10 days and their family then has to isolate for 14 days. If that person who has been contacted by test and trace goes and gets a test and it's positive, that person has to complete their 14 days. Sorry, they're 10 days. They're 10 days. If it's negative, however, the guidance is saying, well, actually, they still need to complete their 14 days because some people can be asymptomatic. If they began to show symptoms, okay, then their family members have then had to self-isolate. They need to continue self-isolating for their 14 days. So coming back to my client's problem at the start of the matter, they said, well, we've had an employee that's tested positive. That person therefore has a 10-day isolation period, irrespective, in my view, of whether they've gone and got, well, they've had the test, haven't they, because they've tested positive, so they've got 10 days. The other people, the other employees who'd been within 2 meters of them, therefore stuck within the car or been sat within a car with them for a period of time, they would have 14 days. Even though those people went and got a negative test, again, they would have a 14-day self-isolation period to do. So the fact that the client has said, oh, we're having these people back into work because they've had a negative test is a bit of a no-no. The rules are positive test 10 days. If they've been within 2 meters of somebody, 14 days, even with a negative test. What did the client pay them? Well, it's SSP, unless there was something more generous under the contract. But as a basic, it would be SSP from day one. So the time that the employer said to them, well, actually, positive test, you're sick, go home, or you may be infected because you've been within 2 meters, go home, that's SSP. Obviously, while I'm touching on pay just briefly, we had a new press release last night, which is the creation of this new payment for people self-isolating in the highest risk areas. The law on this is, or the further guidance in this is yet to be seen, but the government is to implement a new payment scheme for people on low incomes. It's £182 for people who have tested positive for COVID-19. And they're going to trial it in Blackburn with Darwin and Pendle and Oldham. So effectively, where people have to self-isolate, everyone has to self-isolate if they've tested positive or been in contact with somebody. But those who have tested positive will receive £130 for their 10-day period of self-isolation. Other members of their household who also have to self-isolate, given what I've been saying, will receive £182 for their 14-day self-isolation. Non-household contacts who are contacted through the test and trace scheme will be entitled to a payment of £182, which could apply to your other members of staff. There's some evidence regimes that payments will be provided within 48 hours, as long as an eligible individual providing necessary evidence, being the fact they've been contacted by test and trace and they have a bank statement. But again, I reiterate, it's only available for those who are currently receiving universal tax credit or working tax credit, and therefore low income people, but available to the employed and the self-employed. There's not a great deal else to say to that. I can see from the picture at the bottom of my screen that Angela's managed to get her PC working and got logged on, which has saved me having to deal with her questions on the hoof. So, Ange, you probably got the back end of that. I don't know if there's anything that you want to add. I'm going to pass over to you to deal with the other items or the other questions around redundancy, selection criteria, voluntary redundancy work, and how to deal with someone who refuses to attend a consultation. And if you have anything to add to what I've just been talking about, feel free. But welcome and good morning.
Thanks, Keith. Oh, that was a stressful half an hour, I can tell you that, everybody. My laptop decided to have a critical fault and restart for 25 minutes. So cue lots of stressful calls to our wonderful IT department. So thank you to them. Right, okay, so I'm not as prepared as I usually would be, so I'm very much going to do this off the hoof too. So what we've tended to look at, and I have missed most of what Keith said, so I'm sure it was full of wisdom and wise as always. Questions that arose from mine and Elsa's Q&A that we did last week are things such as compiling selection criteria. So when you're looking at a redundancy situation, you need to firstly look at your pool, so who you're going to look to make redundant, and then you need to decide out of those job roles which employees will go. And the way to do that is with a selection criteria. So this criteria really needs to be as objective as possible, and you need to be able to apply it fairly and consistently. The risk with any criteria is that you need to avoid any potential discriminatory elements. So by keeping it as objective as possible, it makes it the safest type of criteria for the employer. So things we would always advise you to look at are things like performance and ability, which is subjective, but you can use things such as the appraisals, disciplinary, etc. Length of service, if you're looking to maintain a certain skill set, attendance, and if you want to look at disciplinary, then you can do so as well. Things like disciplinary attendance, length of service are all quantifiable by records. Performance and ability will be your subjective criteria, and ultimately that will be the area that your employees try to challenge you on the most. One thing that some employers do is they have a look at a criteria and think, actually, what's really important for us to be able to move the business forward? And in that case, you can do things such as add weight to criteria. So if you're looking at a certain profession, you could add skill set. So if you're looking at somebody who's a designer and they have a CAD qualification, for example, then you could add an extra weight to that. Or if you need somebody in a trade who's got specific qualifications or on the job training, again, you would add a specific weight to that. Important thing is always to be able just to justify it. As me and Elsa said last month when we had our talk, as long as you as an employee can justify the criteria and why you've applied it, the tribunal are very unlikely to look behind it, as long as it's not so unreasonable and so out there that no reasonable employer would have done that. One employee did ask me this week if we should just use the last in, first out criteria, and that tends to be a lot less common these days, primarily because you're looking at more dominant criteria. Just because somebody's come in, say, 3 months ago, it doesn't mean they don't have 10 years of experience, which is really relevant to your business. What we would say is sometimes a last in, first out could actually be used as a tiebreaker. So if you've got a criteria and certain employees have scored the same, you could use the last in, first out to split the difference there. The next one, I'm just going to quickly go back and have a look at the slide, is in relation to voluntary redundancy. So how does this work? Firstly, you don't have to ask for volunteers for voluntary redundancy, but it's always worth consideration. It's sensible, really, to minimise the morale of compulsory redundancies, and it also opens your mind up to looking at alternatives to a compulsory redundancy. Things to bear in mind is when you write your letter to all of your staff inviting applicants for voluntary redundancy, is that you don't have to accept it. So just because an employee says, actually, you know, I'll take this enhanced redundancy that you're offering, you might think, oh, I really don't want you to leave us. They don't have to. But things to bear in mind that if you don't select somebody for redundancy, don't hold it against them going forward. And you do reserve the right to absolutely decline any application. So next one. Dealing with the refusal to attend a consultation meeting. Now, this has happened quite a lot, particularly with employees on furlough. First thing to do is understand why. So why are you not going to come along to your consultation meeting? Actually, it's really important for us to understand why you think our process or our decision-making rationale is unfair to you as an employee. And it could be that depending on the reason, you can look at an alternative means to undertake the consultation. So it could be that you look at doing it via Zoom or Teams, or even just on the telephone. It could be in this climate that you've got childcare issues. It could be that somebody doesn't want to use public transport to come into the office. So just try and understand, and there will be a workaround. And actually what we have found recently is people are undertaking redundancy consultations frequently on Zoom and Teams. just to minimise the impact of people coming into the office. Thing to bear in mind though is if your employee is adamant that they are not going to come along and participate in a consultation, it ultimately will have to continue with it in their absence. But what you should always do is warn them that this will be an effect of their failure to attend. And also you need to let them know that you'll be continuing with the meetings without their input. One thing I would suggest is if you are holding a meeting in their absence is take a note of what you've discussed and send it across to them as well. One final point, which I know Keith and David have took off the slide when they thought I wasn't coming because they would have had no idea what I was going to talk about, was whistleblowing. And I could see them chuckling in the background there. A question that I had that came up yesterday actually was a client came to me and said, somebody's come to me and said that their employee said, I've blown the whistle, I'm therefore untouchable. Angela, what does that mean? Well, it doesn't mean they're untouchable, is number one. And I think a lot of people don't quite understand what whistleblowing actually means. So to be classed as a whistleblower, and I'll use air quotes, there needs to be what we call a disclosure of information, which in the reasonable belief of that worker or employee, and I'll come on to the difference in a moment, tends to show that one of a set number of characteristics has occurred, and that's things like a criminal offence, breach of legal obligation, damage to environment, miscarriage of justice, health and safety, just trying to reel them all off there, and the deliberate concealing of any of those. So it's not defined in legislation what a disclosure actually is, but case law tends to say it needs to be more than just relaying information. It needs to be literally disclosing it. So an example that was used in an employment tribunal case, which we use quite a lot, is that a worker saying, actually, you're not complying with health and safety, there's sharps on the floor of this hospital ward. That is a disclosure of information. Saying this ward is dirty, I saw sharps yesterday, wouldn't quite fit the bill. So you will find that whistleblowing actually is becoming far more frequent in claims these days, and that's because there's no qualifying minimum service. So from day dot, an employee or a worker, when I come into the other aspect, can bring a claim, and there's actually no upper limit on compensation like there is in unfair dismissal claims. And as a result, we find they're actually used tactically for this very reason. So there's two types of whistleblowing claims. I'm just going to touch on them very briefly. So the first one is a dismissal. So a dismissal, and that includes constructive dismissal. It needs to be that the reason for the dismissal, and it's the principal reason if there's more than one, is the fact that this employee has made what we call a protected disclosure, so as they've whistleblown. And if the reason for the dismissal is that, the dismissal is automatically unfair. That means as an employee you don't have a defence, so that's quite risky. So employee tells you, gives you a disclosure of information, you go, don't like what they've got to say, going to get rid of you. That's an automatic unfair dismissal claim. The other aspect of a whistleblowing claim is a detriment claim. And now a detriment claim is where an employer subjects its workers, and I use this term rather than employee because the concept of worker and whistleblowing legislation is broad. So it includes agency workers, freelance workers, seconded workers, home workers and trainees, as well as employees. So it's unlawful for you to subject your worker to a detriment. Now this could be threats, disciplinary action, failure to promote, damage to career prospects, loss of work or pay, all kinds of things, just because they've made a disclosure, and that can be a detriment. When you look at a claim in the tribunal, you could have a detriment claim leading up to dismissal, so you've put me through this disciplinary process, and then you could have an unfair dismissal claim as well, only if you're an employee though for the dismissal. So they're not untouchable, but you do need to be mindful when you're making decisions after somebody has made a disclosure information as to why you've acted in a certain way. So why are you dismissing this employee? Have they told you a disclosure, but actually their performance is so abhorrent, you had to go through a capability process anyway? Or have they made a health and safety complaint and you've gone, I don't want this individual in our business anymore? That becomes risky. Right, I think that's a whistleblower tour of whistleblowing and redundancy. So I'll pass you to Keith to see if he's got any comments, and thank you very much for joining.
Sorry, I managed to just begin talking without unmuting myself. Apologies about that. And so David and Angela were fervently waving at me, not for the first time or the last time, I may add, in my life. Anyway, what was I saying? Yeah, I did have a few bits and pieces. I didn't have it to add on whistleblowing because Angie did a very thorough job on that. Not that he didn't do a thorough job on the other bits, I hasten to add. Coming back to your point on compiling a redundancy selection criteria, you were quite right to say that if you consider something, if it's reasonable, employment tribunals can't really look behind it. The other sort of slight gloss I'd put on that is to say it is for the employer to pick the criteria. So long as they are objective and they are measurable, an employer does have a great deal of control to use what it wants to get the outcomes that it wants, in a sense. Because it might be that you are looking for certain skill sets that you're going to need to implement post reorganisation, or it might be that you need certain qualifications post reorganisation. It would therefore be perfectly permissible to build selection criteria that play to those strengths, or to give greater weighting to those things, as Angela has said. In addition, in addition to that, what I would say is look at your business, look at what you need to be able to do the job in question, and if there are specific skills or qualifications that you need to do that, is perfectly legitimate to prioritise those things, rather than a bland sort of run-of-the-mill set of criteria such as performance, attendance, disciplinary and things like that. All those things are important, mind you, and if you want to take them into account, you can. But let me give you an example. I had a client that is an industrial background, and within their production facility, they have 13 major processes that the workers need to do. Some people are skilled to do all 13. Some are skilled to do a handful. Some are skilled and are being skilled up to do 9, and they're working towards getting 10, 12, 11, 12 and 13. What I said to that client is, really, if that's what they need for their business going forward, they can perhaps just focus on those 13 skill sets, i.e. rank people on the basis of each employee, which of them has qualified to do those processes to a satisfactory standard. And that automatically selects the people who are the most skilled people in the organisation to continue running their production facility with fewer numbers. They don't really need to go any further than that. It's objective, it's measurable. You either have the skill sets or you don't. And if they use that to build their criteria, they're not going to go far wrong. Hopefully you see what I mean. Jumping in then onto Angela's, I suppose Angela's third point, the final one on the slide, how to deal with a refusal to attend consultation. I don't disagree with anything that Angela said. What I would say is the lead case on redundancies is William versus Compare Maxam, COMPARE-MAXAM. If you're a sado like me, or if you want to put yourself to sleep at night, print it off and read it. But in effect, it's clear from the judgment in that case that an employer cannot. It says an employer cannot compel an employee to consult. And therefore, if an employee does not want to do so, an employer won't be penalised for that, so long as they've done some of the reasonable things that Angela talked about. Anyway, should you be faced with a situation and therefore have an employee who just doesn't want to get involved, go back, find Williams versus Compare Maxam. It might give you some help. Other than that, I didn't have anything else to add, so I'll pass you back to David, and I'll mute myself again so I don't do anything else stupid. Thanks very much. Good morning.
Thanks both. It's been fun today. I've really enjoyed this one today. Quick reminder from me on content, articles, blogs, podcasts, videos. Q&As or the previous episodes of the Q&As, all on our website at www.sintons.co.uk should you wish to take a look. And you can also follow the employment team on Twitter for all their regular updates at Sintons HR. As usual, I'm just moving back to the details. If you'd like to raise anything the team and discuss further, please don't hesitate to get in touch with them. As I said, details are on the screen. Our next session, because we've moved these to a monthly format now, will be Friday the 25th of September at 10 AM, still on Teams, and I will send the link round to everyone near the time. So from us, thank you very much for listening again this morning. Stay safe, have a great weekend, and we'll speak to you in about 4 weeks' time. Thank you very much.